Ever since Ron DeSantis in Florida decided to go after the entirety of the Hispanic community, they've had a labor problem in Florida. The people that do the work don't want to work in Florida. Now we got the politicians in Florida changing the law, or trying to change the law, to just fill those roles with kids. Fuck those child labor laws. HB 1225 and SB 918 would further erode child labor protections in Florida. In the 2024 legislative session, the legislature passed House Bill HB 49, Employment and Curfew of Minors. It is amended. In its amended form, the bill that passed was less harmful than what was originally proposed thanks to strong advocacy. In the 2025 session, the legislature filed SB 918 and HB 1225, Employment of Minors. The proposed rollbacks to child labor laws would pose an even greater risk to the health and well-being of Florida youth than those contained in the original version of HB 49. If passed, HB 1225 and SB 918 would allow employers to schedule any 16 and 17-year-old Floridian for unlimited hours and days without breaks during the school year, and schedule 14 and 15-year-old Floridians who have graduated high school or are home or virtual school students for unlimited hours and days without breaks during the school year. Florida laws governing children's work hours have changed numerous times since they were first enacted in 1913. The last time Florida lawmakers dramatically changed the hours children could work was in 1986, extending the curfew and ban on working more than 6 days in a row to those aged 17 and younger. Before this, the law only shielded children aged 15 and younger. Many of the changes proposed by the bills would take Florida back to the 1980s and beyond. Both of these bills would impact all 14 to 17-year-olds in the labor force. Workforce data is most reliable and available for those aged 15 to 17, so estimates cannot be provided for 14-year-old Floridians. Based on teen work trends, FPI estimates that 111,311 of these teens are in the labor force and could be directly impacted by the bills. In the labor force is defined as those who are actively looking for work or who were laid off and are awaiting recall as unemployed. Otherwise, they are not part of the labor force. This includes 95,194 teens who are currently employed, 86% of all 15 to 17-year-olds in Florida's labor force. The data tells us that most teens this age who are seeking work already have it. Eroding Florida's child labor laws is unnecessary. Enrollment data is available for working Floridians age 16 and up. Among the 83,847 teens age 16 and 17 employed in Florida, there are an estimated 60,264 juggling work and school demands. That's 71.8%. If these bills are passed, they will remove nearly every state guardrail that helps ensure youth are not too exhausted to perform well in school and other extracurricular activities. If employers are no longer required to consider school schedules, this will leave youth who are striving to complete school while holding down a job with an unfair choice. Accept the hours their boss schedules them and put themselves at risk academically, or lose their job and the money and experience that comes with it. Youth living in poverty and immigrants without a documented status will be especially unlikely to view quitting as a viable option. So, it appears as if the state of Florida is going to solve its Latino labor shortage problems by just putting their kids to work for longer hours and days. That sounds about right.